Yes.
Adjournment request, if any, from item number 1 to 5. From item number 6 to 15.
Lordship, I beg to mention items 7 and 8 of today's list. Here,
7 and 8.
yes, Lordship, we were required to file an affidavit. In item number 8, we have filed our affidavit, Lordship. And in the mean, for item number 7, some changes were required, Lordship. Within this week, we'll file the affidavit.
If the case is same, you can replicate it.
Lordship, some difference was there in the other one. That is why we need to be.
You are for the,
I'm appearing for Finance Department, Lordship.
what's the name?
A. Solia, Lordship.
Mr. So-and-so, learned advocate. Yes, any problem?
No problem, Lordship.
Mr. So-and-so, learned advocate appearing for the Finance Department submits that counter affidavit in WPC number 6118 of 2025 is yet to be filed.
Lordship.
In all its probability, the same shall be filed by the on or before the next date. So, counter affidavit in WPC number 6187 of 2025 has already been filed. So, a request therefore has been made for an adjournment. The prayer is allowed. Let both the writ petitions be listed on. After 2 weeks?
Lordship.
Yes.
18th May.
May I please your lordship?
Louder.
May I please your lordship?
Yes.
I beg to mention item number 18.
Item number?
18.
18.
18.
Yes.
With the consent of other side, lordship, my senior is unwell.
Who is leading you in this matter?
From AFDC department,
Sharma.
Mr. P. Sharma, on behalf of Mr. P. Sharma.
Okay. All right. As prayed for on behalf of the appellant and agreed to by the counsel appearing for the respondent, the matter is adjourned to. After 2 weeks, 3 weeks? After 3 weeks. Correct.
16th June.
Lordship, with regard to item number 16 and 17, Lordship, we had set with an adjournment slip yesterday, Lordship.
Adjournment. But who appears in item number 16?
16, Lordship. Yeah.
So both matters would be adjourned.
Common against a common.
As prayed for on behalf of the appellant. WA number 200 of 2022. The matter is adjourned to so-and-so date. List this appeal along with WA number 237 of 2022.
It's an interim order, Lordship, that is to continue.
Interim order, if any, in the meanwhile shall continue.
Lordship.
9th June.
Lordship.
My lord,
Yes.
with consent of the petitioner, Lord, I beg to mention item 19.
19.
19, my lord.
Hmm.
Can it be some other day, my lord? Subject to a lordship's convenience, my lord.
What is this matter about?
In fact, my lord is challenging the rule
All right. You appear for
for the respondent, my lord.
Standing Counsel Cooperative
My
Department.
lord.
Cooperative Department.
Cooperation. My lord.
Cooperation.
Cooperation.
All right. As prayed for by Mr. Talukdar, learned Standing Counsel for the Cooperation Department, and agreed to by the counsel for the petitioner, the matter is adjourned to give a date after 4 weeks.
18th June.
Obliged, my lord.
Please, my lord. I beg to mention item 23.
23 is with 24. Yes, what is this matter?
I'm appearing on behalf of Mr. PJ for respondent 1.
You're appearing for respondent number 1. And who appears for the appellant?
I am for the appellant, lordship.
Have you taken consent? You've
Lordship,
taken
Consent in item 23 and 24 as well, my lord.
both.
I-
As prayed for on behalf of respondent number 1. And agreed to by the counsel for the appellant. Both the appeals are adjourned to so-and-so date.
18th June.
may be continued, lordship.
Interim order, if any, in the meanwhile shall continue.
Much obliged.
तो मैं कर देना.
This one. Yes, Lordship.
May I please, your lordship?
Hmm.
With consent of the other side, your lordship, I beg to mention item number 25 and 26. Here, your lordship, I am seeking an adjournment, your lordship. The paper book has not yet been furnished to me, your lordship. So far as other councils are concerned,
28.
paper book has been furnished, but So
Why
I am
has it not
concerned.
been furnished to him? Mr. Courtmaster,
Yes,
would you know why the paper book has not been furnished to Mr. Botakur? Just check up. As prayed for on behalf of the appellants. There is this is sole appellant, no?
Yes, Your Lordship.
And who appears in the death reference matter?
GL Kamar, senior advocate.
Where is he?
I have informed him that I.
You have
will get
informed.
back.
As prayed for on behalf of the appellant. But we will not give a long time
Lordship,
to
Lordship,
after 2 weeks.
Lordship.
Unless this matter on priority, in priority on after 2 weeks. In the meantime, the paper book must be furnished to Mr. S. Botakur,
Lords,
learned advocate appearing for the appellant.
Lords. Deeply obliged.
7 May. 7.
Please, Lordship.
Yes.
Lordship, by taking consent from the other side, I beg to mention item number 1 of supplementary list, Lordship.
One of supplementary.
Yes, Lordship. Lordship may kindly adjourn the matter for today only. And may list after a week.
WBC 43101.
27, item 27.
Item
27
number-
with 28 with 29 with 30.
This is also related to item number.
Okay.
Case number, please.
Oh.
Supplementary.
Huh? Okay, supplementary one. Okay.
Yeah,
Yes,
27, 28.
No, sir. This will be also supplementary.
Yes,
The
number, please.
Supplementary, this has not be by two supplementaries.
What do you want in this? So one, if you mention in 27, then 28, 29,
I
30.
probably he's mentioning item number one
One,
of
one,
today's
one.
list. Malad, writ petition number 4301 of
One,
2018. I pay
supplementary.
for the other side, Malad.
All right, you're mentioning one.
Yes,
Why
Lordship.
do you call it supplementary list? Today's
it-
list is supplementary list.
Because the notice probably, Malad, it's mentioned as.
All right, as
Supplementary
dates,
list.
what do you want
Lordship may kindly adjourn the matter for today only.
for today only?
Yes, Lordship.
Admission में आ सकता है क्योंकि amended cost title हो गया.
Sab ho gaya.
हो गया.
I think let this matter come up for admission on, give a date after 2 weeks. Get ready, because the name of respondent number 6 has been substituted and fresh memo of parties, it has been deleted and fresh memo of parties also has been filed. So I think it's right for admission.
Right, sir.
Let this matter be listed for admission on.
28 May. 20.
28.
20.
Chal.
Not sure.
Any other request? Supplementary list for orders item 2.
Contract review is pending. Last order.
Lordship,
Yes, Ms. Chakravarti.
Lordship, before my friends begin, Lordship, we have filed the review. Let the content be listed along with the review. Review petition 4 of 2026, Lordship.
3110.
And this is common judgment. In the other writ petition, we already filed a review in which notice has been issued, Lordship.
Now you would be further making yourself amenable to contempt.
Lordship.
What review, on what grounds?
Lordship, there is a judgment of the Supreme Court that was not brought into the Lordship. That is.
Judgment of the Supreme Court was not taken into account while passing the order. And what was that judgment?
It is in single, I have annexed that in the review petition.
So where is the review pending?
Union of India versus Gandhiba Behera.
Where is the review pending?
Not yet listed, Lordship.
Have you filed it?
Yes, Lordship.
When have you filed it?
Review petition 4 of 2025. Registered on Lordship January, in January, Lordship.
Have it listed for, the review petition would be listed before which court?
Division bench, Lordship.
So someone.
The bench has to be constituted. I'm posting this matter for after 2 weeks. By that time, if your review is not listed, we might not wait for that review.
Lordship.
I pray, my lord, the date may be fixed, my lord.
2 weeks, we will not say 2 weeks, we'll fix a date. Yeah. Let this contempt case, let this case be listed along with review petition number
4 of 2026.
4 of
2026.
26 on, give a date, 2 weeks. In the meantime, you have it processed. If, have it processed in the registry. If at all there is some difficulty, you come and mention before.
If it's registered and there is no mistake.
Then why should it not be listed?
You have to consider the bench in administrative file.
My lord, it was a file, my lord. It was supposed to give me copy, my lord, but stop with the copy, my lord.
No,
No.
just a minute, just a minute. So this review would go before a bench of which one of the members would be Justice Saikia.
Lordship.
Correct. You place the file before me, we'll have the bench constituted. Make a note.
Yes.
Obliged.
All right.
Item 3.
Last occasion, your lordship saw that it did.
SLP has been dismissed, no?
My lord, my latest instruction is that, my lord, as per advice of the Supreme Court counsels, a review has been filed. Of course, it is a last rites to be performed, my lord, a review in Supreme Court, my lord. The review
Anyway,
was filed on
whatever you-
3rd of March. It's not-
Whatever you have to do, you do that. Now on merits, Supreme Court has affirmed the order of this court.
My lord,
Correct?
my lord,
So nothing is left.
nothing is left.
You think there'll be some scope in review?
No, my lord, only the last nail on the coffin.
Yes,
When have you filed it? Have you filed the
On
review?
3rd of March, my lord,
You have filed it?
my lord.
Give us the number.
The diary number is, my lord, 13596 of 2026.
As per my
13596.
is always objection.
The learned counsel for
They did
the,
not clear the objection, madam. As per note office, madam.
if they don't do it, we will ignore that. We'll say that this is just a ploy. Don't worry. You have been successful from this court, from Supreme Court. Now nothing can be done by them.
Madam.
Anyway, we'll see what is there, what we have missed out for entertaining a review petition. We'll see that. Yeah, Mr. Kanavan. Mr. Pathak, learned advocate for the, you are the standing counsel revenue.
No, my lord, BSNL.
Standing on
Yes,
BSNL.
Mr. Pathak, learned standing counsel for the BSNL submits that a review petition has been filed against the judgment passed by this court, whose diary number is so and so. Take the diary number. Stop.
13596.
It may be noted here
of
that the judgment of
2026.
this court was put to challenge before the Honorable Supreme Court, where the SLP was dismissed. Let this contempt case be listed along with the review petition.
No, my lord, the review is before the Supreme Court. Against dismissal of the SLB, there is a review. filed.
Then we don't say anything. Then for that matter, we don't say anything. Mr. Pathak, learned standing counsel for the BSNL submits. I thought that under the advice you have come here for review.
No, my-
Mr. Pathak, learned standing counsel for the BSNL submits that a review petition has been filed before the Supreme Court against the dismissal of the SLP referred against the judgment of this court. Stop. He therefore seeks a short adjournment. Let this matter come up for consideration after 4 weeks. After 4 weeks, nahi likhna, on swear for that.
My lord, I have another prayer, my lord. Same order, my lord, other two contents pending. Same may be also listed along with.
Without it being listed, we shall not pass the order.
In fact, one matter is listed tomorrow, probably.
Oh,
But tomorrow you have the same order.
22nd June. Item 4.
Along with 27, 28. on-
Well, on 15/5/2018, 12/9 and 19.
Just a minute.
Mine.
These 27, 28 and all.
on-
You're appearing in 27, 28 and
My lord, I'm appearing in item number 4, my lord,
that's all right, but there are matters,
in supplementary list.
cognate matters, item numbers 27 to 30.
27 to my lord 31.
So who appears in these matters?
M. Soronia and BD Das.
Vijay Mukherjee.
Item number 27.
So you will be adopting his arguments.
My lord, I have my own arguments. also.
That's all right. So we are just hearing them. Are you ready?
No, sir.
Okay, all right, yes.
And my lord, so far as my lord, the return is concerned, my lord, we have filed our counter affidavit in item 27. And that affidavit we will be relying for purpose, for all
Correct.
purposes and
Correct.
intent.
You have no problems?
No problem. In that case, a copy may be served to me.
I will, right.
Serve him a copy. You won't have the copy
We have
served,
it.
then we hear you tomorrow?
My lord.
Tomorrow, day after tomorrow,
Yes,
next week?
Because last date is on 30th May. Advertisement.
Then we hear tomorrow. Give him a copy of the certificate.
Yes, definitely.
And you also file it in the registry in this case. So you'll not be required to make necessary changes.
My lord,
I think the issue would be the same.
I will right now, my lord, serve him a soft copy. My lord, it is available with me because this item number 4 has come for the first time, my lord. And these matters are already pending before this honorable court. And my lord, in general, we are defending the
We
amendment.
will decide the issue. Have they challenged the rules? No.
Yes, yes.
That is why.
I think the arguments would be the same.
Absolutely, absolutely,
Look here,
absolutely.
let WPC number 2071 of 2026 be listed along with WPC numbers 143 of 2026, 7408 of 2023, 209 of 2025, 693 of 2025, and 1865 of 2026. Tomorrow, that is on, day after tomorrow. Day after tomorrow, that is on so and so date.
23rd.
Obliged, deeply.
I'm so obliged.
Those RCC trained persons
I'll succeed.
are nominated by BTC. You say that they are not entitled.
They're not in that.
All right.
I'm so obliged.
List them up.
Item number 5.
Yes. Yes.
Like the matter relates to the pension, my lord, in respect of the second wife. We have, my
That
lord,
has been denied to her
denied to her.
on the ground that the first wife is still surviving, and under the rules, if there are more than one widows, then the elder one gets the share.
Yes, share. We have, my lord, while taking the recourse to the full bench judgment of this honorable court, the full bench again.
And the rules in that regard. Rule note appended to rule, some rule. I think you have argued it once, no?
143.
Anyway, yes.
The only thing is that, my lord, taking the full bench judgment of this honorable court, the learned single judge said that case is dismissed. The writ petition is, the writ petitioner, who is the second wife, is not entitled. But, my lord, if we go through the full bench judgment, especially in para 22 and 23, over there it says that right is not totally wiped out in respect of the second wife if she is governed
Correct.
by.
She has to be the custodian of the money.
Yes, first wife.
I think that observation is very difficult to be executed. Now, how would it be done?
My lord, only
Unless the shares are allocated
over
for
here-
children and for others, if they don't maintain, then that would entail and would require another petition to be filed by you. But here the question is, the single judge has quoted those relevant provisions, relevant paragraphs from the full bench judgment.
But
Correct.
incidentally.
So, but so far as the entitlement is concerned, unless you obtain consent from the first wife,
My lord, incidentally, paragraph 22 and 23 of the full bench was not taken care of.
no, it has been quoted. If we are not mistaken,
Yes.
let it, please come to the impugned judgment.
Turn and paste it, 6.
The single judge was very careful in extracting paragraphs 19, 20, 21, and 22 of that judgment. Zunufa Bibi.
Yes, yes.
Hmm.
My lord, those are the.
Come to internal page 6 of the judgment.
I've got it, my lord, page 175 of the.
That's right. Why, how do you say that it has not been adverted to or not been given due importance or not taken into account?
My lord, another is paragraph 23 was also there.
What is paragraph 23? Let's have the full court judgment. Full bench judgment rather. I always.
It's already reported for ready reference. That is
This is
internal
good to
page
see.
11.
What was that? It's a non-executable order. Paragraph 23. Yes, read paragraph 23.
We also provide that in the event of any such other persons who are entitled to the benefits of the family pension in terms of Rule 143 of the Pension Rules of 1969, including the second or further wives in a case where the parties are governed by the Mohammedan law, are not appropriately maintained by the eldest of the surviving widow or wife to whom the pension would be paid, the remedy thereof would be to make a claim for maintenance in the appropriate forum under the law and not a claim for a payment of the family pension by the state authorities directly to such persons. But however, if in a given case, the state authorities on their own volition are of the view that the under an acceptable circumstances, the authorities are agreeable or required to pay the pension separately to any such member of a family.
And what would be the correct forum to go for that? Suppose these observations were to be executed, then which is the forum where the second wife or the children from the second wife would go to? So therefore, this observation in paragraph 23 to our mind is inexecutable.
We'll have to
constitute a full pension. Who appears for Moriam Begum? You're appearing. And who appears? This is railways or something else?
No, education department.
Yes, education department, what do you have to say to this? Now suppose, they have unnecessarily challenged this single judge's order here. In fact, if Zunefa Bibi was relied upon, then perhaps their forum lies somewhere else. Now, in case they go before the authorities, the second widow, on the strength of her nomination in the pension papers, or perhaps in other documents, if she goes before you and says that you ensure, you please give pension to her, but ensure that she maintains the other family. Perhaps the second wife has been evicted from the home. Then in that case, what would you do? Now you're only shaking your head. You have to tell us, otherwise, see, this judgment will be required to be reviewed and we might be required to constitute a full bench. Because this judgment is of by a court of larger strength. We can't tinker with it unless dealt with judicially. But to our mind, paragraph 23 makes this judgment neither here nor there. The position remains, it goes in a flux. I think at 22, the bench should have stopped, if at all that was the view. What to do? You file your response to this.
only information before this court, I will give my note. At present, around 20 lakhs they took it, and
the difficulty is that when this matter was being argued before the learned single judge, you did not let the single judge know about the law laid down with respect to children from the other widows. The pan India, the decision has been otherwise. It says that all children, legitimate or illegitimate, would be entitled. Where did you say that?
over here in the pension, it is in respect of the minor children.
Therefore, the learned single judge only took it that it was a dispute between two widows. The elder one had probably left the house. She is also receiving her pension because she was Anganwadi Sevika or something. And she has a son who is a teacher. So therefore, where was your contention that she has to be the custodian? If you're relying on Zunefa Bibi, then perhaps something has to be done in the first instance. You have to say that if this doesn't happen, then the department shall take care.
It was said that I am left.
Oh, you're not understanding one thing. So far as judgment is concerned, how do we question it? It is based on a full bench judgment.
I understand.
We also can't tinker with it. But
Yes, sir.
frankly speaking, we are finding it difficult to digest it for the reason then it becomes very, very inexecutable. Much to the chagrin of Mariam Begum, but this is not executable. So either that paragraph is a side swipe. What is it called? The side wind, the parenthetical statement not being included in the ratio. The ratio is the first wife because of the rule. So this means nothing. There has been an exposition on the rules. I don't know whether you are following the difficulty of this bench.
I understand.
Mr. Talukdar, Mr. Talukdar, you just find out what would be your response in case a petition is filed there. How is this to be handled? इसको admit करते हैं. तो admit करके एक डेट लगाते हैं. नहीं, जुलाई तक ये जुलाई तक नहीं वर्क करेगा तब. Mr. Talukdar, your department loses out on nothing. Whether you'd be entitled to allocate, that instructions you have to take, you have to do some research work. That, I remember of many cases which I have held, which I have dealt with in the past, another jurisdiction. Children cannot be denied of that benefit. So merely saying that widow number one would act as a custodian, that is an empty kind of a direction. Now what happens if she doesn't do that? Then would you, if the petition comes to you, would you take a call? You can. You can. Find out, do some research, go to the annals of Patna High Court and Delhi High Court. I think you will find many. Because these things keep happening in Muslim families. I don't remember as of now, but paragraph 23, no matter how beneficial it is for the family, it is very difficult. There is no forum where the second widow can go. Especially in view of the noting in the rules that she is entitled, not entitled, then she will be entitled to raise this issue. That for all practical purposes, the animus, the intent of the employee was that all the benefits should go to her because she was nominated. What we intend to do is this. We'll admit this. You file your response and we'll fix a date. We'll hear it and decide. And give us all the relevant parallel judgments of different jurisdiction. Rules notwithstanding, regardless. Rules can be interpreted. Rules can be interpreted. Suppose the second marriage, there is no validity. Suppose there's an Indian family. It doesn't talk about Muslim families only, the rules. There could be a situation where a second marriage, otherwise it would be void under the Hindu law, but validity has got nothing to do with the pension. So in that case, there has been decisions, I know, where it says that the children born out of the wedlock of another wife, whose marriage may be in doubt, but then they can't be divested. So you'll have to do some research work as an employer, as a person. You don't worry on that count because that is the only slot that you'll have to spend. How does it go is something is in your court, in your courtyard. The ball is in your hands. Let's see. Take that. क्या नाम है इनका? We have heard Mr. J. Abedin, learned advocate for the appellant. Mr. B. Sharma for the Standing Counsel Accountant General, Mr. Talukdar, learned Standing Counsel Department of Education, and Mr. Ditul Das. Mr. Ditul Das for respondent number 9. The challenge in the present judgment, the challenge in the present appeal is to the judgment dated 30th of September 2024, passed by a learned single judge of this court in WPC number 5963 of 2022, whereby the claim of the appellant as a second widow to receive pension on the death of the employee has been rejected. The appellant claims herself to be the second wife of the deceased government school teacher. Who had approached the learned single judge for a direction for 50% of the family pension of her late husband, along with arrears and other benefits under the Assam Service Pension Rules 1969. The contention raised on behalf of the appellant before the learned single judge was on the strength of the nomination in her favor in the service records of the employee, despite her being his second wife. The appellant, who got married to the employee in the year 2012, gave birth to 2 children who are still minor. The first wife of the employee it is claimed has an independent income source, namely her pension as an Anganwadi worker. She has 6 children, one of whom is employed as a teacher. Mr. Abedin, learned advocate for the appellant, submits that there are extensive evidence the marriage of the appellant with the deceased employee being legitimate. The other documents on which the claim is rested is evidence of conjugal life, the birth certificates of children, entries in the service book, apart from the employee data capture form under various schemes. Her inclusion in NRC, passport, and Most importantly, a pre-death affidavit by the husband declaring equal pension shares for both wives. It has further been brought to the notice of this court that post the death of the employee, the first wife evicted the appellant from the matrimonial home, forcing her to live with her parents under great financial hardship. The learned single judge, relying on a full bench judgment, of this court, मसोमत बोलते नहीं हाँ मसोमत जुनूफा बीबी versus Mosammat Padma Begum alias Padma Bibi and 4 others. Where is the judgment? अभी जो हम पढ़ रहे हैं. Has held that under the pension rules of 1969, the only person entitled to receive family pension would be the first widow. Regardless of the nomination of the appellant, pre-death affidavit of the late employee the contention of the appellant is that though the relevant paragraphs of the full bench judgment has been extracted by the learned single judge in the impugned judgment, but succeeding paragraph number 23 was actually left out, which would have given the right to the appellant to pursue her claim for 50% of the family pension amount. For the sake of completeness, we deem it appropriate to extract paragraphs 19, 20, 21, 22, and 23 bracket mein, which paragraph has not been extracted in the impugned judgment. The full bench judgment. Then take paragraph 19 to 23. (19 to 23). the entire full bench judgment is based on note 1 appended to Rule 143 of the Pension Rules of 1969, which clearly reads that in cases where there are 2 or more widows, pension will be payable to the eldest surviving widow. On her death, it will be payable to the next surviving widow, if any. The note further specifies that the term eldest would mean seniority with reference to the date of marriage. The pension awarded under the rules 143 will not be payable to more than one member of an officer's family at the same time. It will first be admissible to the widow/widower, the pension, and thereafter to the minor children. In the event of remarriage or death of the widow/widower, the pension will be granted to the minor children through their natural guardian. In disputed cases, however, payments will be made through a legal guardian. Legal guardian. While expatiating on the reach and extent of the note 1 appended to Rule 143 of the Pension Rules of 1969, the full bench referred to above was of the view that in case of more than one widow, and the eldest receiving the pension, would in fact be the custodian of the amount for the benefit of the entire family, which would include the second widow and her children, if they are otherwise entitled for pension, if they are otherwise entitled to be maintained out of the pension. That way, the recipient of the pension, if it is the first widow, she would only be treated as a trustee of the amount received as family pension. For all such other persons who would be entitled to the benefits of family pension in terms of Rule 143 of the Pension Rules. What the learned single judge, it has been argued by Mr. Abedin, completely ignored was the further observation of the full bench that in case the first wife receiving the pension in a Mohammedan family, which is governed by Mohammedan law, does not appropriately maintain the others, the remedy would lie the remedy for the claimant would lie for seeking maintenance in an appropriate forum under the law and not a claim for payment of family pension by the state authorities directly to such persons. The observation further indicates that the full bench intended to give that passage to the departmental authorities / state authorities of their own volition allocate the shares to the legally entitled recipients of family pension. Under such circumstances, note 1, 2, rule 143 of the pension rules of 1969 would not come in the way or would pose a complete bar to such separate allocation. Separate allocation. That the learned single judge only ruled that the claim of the first widow is undoubted, leaves the appellant, the second wife, absolutely remediless, except by way of approaching the pension giving authority for allocation of her respective share. Talukdar to take instructions in the matter. Mr. Talukdar, this court has requested Mr. Talukdar to take clear instructions in the matter as to the stand of the pension giving authority in such circumstance when the first widow / respond number 9 refuses to part with the pensionary amount for the sustenance of the family of the second widow, especially when the first widow has her own sources of income, whereas the appellant is solely dependent on her parents for maintenance of her 2 minor children. This court would also like to have the written response of respond number 9 / the first widow before we finally decide the issue. Let the respective affidavits on behalf of the state and respond number 9 be filed positively by the next date. We dispose it off in the admission stage only. The case laws, I don't remember it offhand. He will take instruction. He will confer with the advocate general. Let's see. On that day. देखें see. वो क्या कैसे object करेगा? If the state decides,
propose देने से भी
then
the objection is that we can
let them write it in their affidavit.
that is
The pension giving authorities, necessary affidavit from anyway, you file your response, whatever it is. The response affidavit of respond number 3 also shall be filed by the next.
Not only one information, my lord, possibly a lot
After
more.
2 weeks, no, not after 2 weeks, they'll have to work. Keep it in July first week, July second week. July second week.
15 July.
15 के
July.
बाद वाला जो week.
Yes. 22nd July. 22/7.
हम अगर चले जाए ये कर देंगे बजट.
I wanted to say on one line, this court may say, why didn't you inform us earlier? Now presently, the pension and other benefits have been already taken by the first wife. She did not give me anything. I'm working in a bakery, only this information.
No, that's what we have said that. See, we would not necessarily be governed by sympathy.
Yeah, I
Now,
understand.
So therefore, you don't tell us all that. Even if you had other source of income, whether you had your entitlement in the family pension or not, that we are dealing with. Because otherwise, if we start looking at the woes of people, I don't think we will be able to decide cases. This is our greatest difficulty. Though we are not insensitive at heart, a lot of feelings are there. But the moment you get swayed by those sentiments, then perhaps it is difficult to decide in a dispassionate way. No, we are talking about your entitlement, pursuant to not pursuant to the rules, but pursuant to the observation of the full bench. That Mr. Ditul Das is only a trustee. He can't appropriate the entire amount. Correct.
Deeply aware.
Let's see what we do. Let's see their stand, because that is the only forum then, no? Where would you go? Which civil court?
Nothing.
Nothing. So therefore you have to go there. They will only decide by rules. So they have to decide. And you also file your response. Not that we have not heard you. You also require.
The only thing is that they have stated that.
You are not even living with your husband.
Oh, no, Lords, that the submission made by the appellant that the second one has been evicted. That is not correct, Lords.
Correct, you dispute that.
Item number 6. Sorry.
Make it very clear, we are not going on sentiments. It's only on the basis of entitlement.
Item 6.
Yes.
May I please, as a lordship, my lord was pleased to issue notice, no response and date.
So far as lordship, this matter relates to firstly, there was a.
No, have you filed your affidavit?
I have not, because it perhaps will not be necessary.
No.
Because
That-
lordship will see, his prayer is issuance of gun license to the.
No,
indigenous
forget
people.
about you.
That will be.
State.
The Advocate General had accepted notice on behalf of the state and said that he shall be filing his response, no?
One instruction has been received from the SP lordship.
SP will do what?
They have stated if he had.
But don't go on one small thing, the issue, then we'll be required to give an introductory note. Still. Look here. The petitioner is a students' organization dedicated to the welfare of society, more particularly protection and upliftment of minorities in Assam. Their concern is that the Bengali speaking Muslim community in the state of Assam are being targeted in many ways. Stop. Instead of they being protected, the state, it is alleged, has introduced certain policies and measures that adversely affect them through backdoor. Some of the policies which have been named in the writ petition are the special scheme to grant arms licenses to indigenous people, vulnerable areas, which according to the petitioners could escalate violence, which could escalate communal tension. Even the eviction drives, it is alleged, are carried out in an arbitrary and inhuman manner, without following the due process of law. And more often than not, it targets specific minority groups. In reading of the averments made in the writ petition, is that the allegations are very general and vague. There could be myriad reasons for grant of license to indigenous people in vulnerable areas, which may not necessarily be for the purposes of targeting the minority community. An overgeneralization has been made in the petition. Next, nonetheless, on an earlier occasion, notice state was accepted by the learned advocate general. Who had submitted that the response to this petition shall be filed by the next date. R.B. Bora, learned advocate for the state, submits that all necessary instructions have been received. That necessary instructions have not yet been received, and therefore counter affidavit in this matter has not been filed. She has submitted that by the next date counter affidavit shall be filed, re-notified to after 8 weeks.
27
Mr.
July.
Chaudhary, you were saying that it is not required. Why?
If any gun license has to be issued.
That's what we have said.
No, that will be as per the arms rules.
Correct. See,
So
this
if
allegation has
they-
to be, so this is the answer. No, why it is not required? This is the answer. This is the answer. You can't call every action of the state to be damaging to you through backdoor.
27.
So therefore, this is the answer. But the concern shown by Mr. Bhuya has to be taken into account. Why do you say it is not to be? See, unless you say, because see, vulnerable areas, indigenous people, if you grant license, then there could be some problem, there could be some reason for people to suspect that this could escalate violence or whatever. I mean, some decisions have to be taken keeping everything in mind. So you need to respond. We would like to see the response of the state, no? It's not something, of course, the allegations are general and vague, but then it requires a response. Yes.
If your lordship has noted, the organization pertains to the BPC area and the allegations are for some upper Assam.
Anyway, you file your response, no? We can't shut our eyes to these allegations. Otherwise, what is the forum? Where would he come? Yes.
28 July 20. Item 9.
Okay, number 9.
Let's may it please you, my lords, fellows, and item 9.
Yes.
Just take a couple of minutes, fellows. One, fellows, your lordships passed the order of notice on 26th of February, and your lordship, fellows, does not have any reply till now by the contesting respondents.
Why?
Number two, fellows, what is more important is, fellows, it's a half-page note. After your lordship's order, notice issued, which means prima facie case found, and without, fellows, filing a reply.
Mr.
just give their
Singhvi,
half page
your voice is trailing off at times. Either you'll have to look, you'll have to speak in your microphone. For looking at the
I'm very
files,
sorry.
when you recline, I think I can't hear you then.
I'm very
You
sorry,
have to
Malas.
speak on the microphone.
Yes, Malas. Well, I'm very sorry. I hope I'm now.
Now it is all right. You're very audible.
Just give me 5 seconds. I'll just adjust this.
Yes, I give you 10 seconds. But then the visual is very shaky.
Now I hope
Your
Malas,
voice is breaking, visual is
relatively
shaky.
more-
Perhaps you're on the move.
Malas, no, not at all. Malas, I'm very stationary. And that is not to comment on the strength of my case also. There must be something wrong with technology, Malas. I'm
Nothing.
very strong foundations on the case. Something wrong with the technology. Now I'll take literally 2 or 3 minutes only. Malas. Apart from not filing a reply and your lordship's notice now being about almost 2 months old or just under 2 months old, please turn to this half pager. Kindly hand over to my lords. Have you handed over, madam?
Yes.
Well, this is not done with great disrespect and humility. After your lordship's order of a notice, 27th of March, he says this. I'm not even reading it because I feel a little hesitant to read it. In item 1, backbone, and then those who came from so-and-so encroached will have their hands and legs politically. Backbone, and the word Miaz is used again. Then on 17th of April, he addresses a rally and says, can anyone, well, these are all religiously provocative, incendiary, needless comments. Is anybody suggesting that they are building the Babri Masjid in Assam, Malas? This is deliberately provocative. Then 18th of April, his entire thought process is reserved for a minority only. He thinks, breathes, speaks, imagines only that particular minority. Then 18th again, and then finally 20th. Look at 20th. Well, let's forget a constitutional functionary who's supposed to maintain the peace, maintain balance, maintain Malas's sobriety and a maturity. Forget all these nice words. An ordinary man on the street is not supposed to be allowed to do all this remotely. And when the court is on seisin, it appears as if there is no, in his eyes, there is no regulatory, judicial, adjudicatory framework at all in an actively sub judice matter. After your lordship notice, that is why I said, your lordship should form some part of an interim order. There should be some part of an interim order, some form of an interim order.
Please, Learned Advocate General.
People can't have a license, without an interim order of your lordship, they just go on having a license.
Lordship, Learned Advocate General is in court 8 in another matter, but I've
He's in
entered
court 8.
I have entered appearance for respond number 3, my lord.
Right, only 8 weeks, 7 weeks.
For respond number 3.
No, but
I want some time to file a response, my lord.
I mean, but you can't continue, evading filing your response. No, it has to be filed.
This is the first time I'm appearing for
First time you're appearing. All right, first time. Correct. But then notice was issued. When did you receive the notice?
Lordship, notice I received on 20.
Anyway, we will give you time to
31st
respond.
March.
It's something directly related to you. Therefore, you will need to respond. That whether it is justified, whether you said that. I mean, they say that they have gone on record saying this, but let's see. Let us have your response positively by the next date.
Lordship, at least 4 weeks may be granted, my lord.
But that don't take further time and copy in advance.
Lordship.
Copy to the Learned Council in advance. Local council, Mr. Singhvi, you have, Ms. Arora, do you have a local council here?
Mr. Namni.
Yes, hello, my link is a little bad. I do have a local counsel.
Local council only for our identification. Local council only for our identification so that we ensure that the reply is, the counter affidavit is served on them.
Mr. Namneet Balas is the name given. I will agree. Tell your lordship's court master the mobile number and all that. He should be there.
All right, all right.
Only one sentence, well, only one sentence. Well, it's, I mean, your lordship is kind enough to give a date and all that, and they will complete the pleadings. Well, there should be some observation of hope and trust. Now the elections are over. Let him hold his peace, well.
That may not be necessary, Mr. Singhvi. Now the real vulnerable days are over, but we will take up this matter and on the next date we shall decide.
Well, the principal respondent doesn't look for vulnerable days, well. Every day is auspicious for these remarks.
Now, in his absence, we can't, let that response affidavit come.
Very well.
Let the response have, let us also show that responsibility that no comment on any person who is not before me.
The shortest possible date is all that I can ask for.
4 weeks,
They've taken
I think
already
is good
7
enough.
weeks.
4 weeks. 4 weeks you must do that. See, this time appears to be critical when nobody is free for some reason or the other, but then 4 weeks.
Would my lords consider 2 or 3 weeks, then I can file a rejoinder in 1 week
No,
and
the
be
copy in
over
advance. Look here, it has been submitted on behalf of the state
3 weeks by them, 1 week by
that
me.
the response affidavit shall positively be filed by the next date with a copy served in advance to the counsel for the petitioners in the respective writ petitions. List all these matters on. No, before a copy in advance. 4 weeks. Give a date after 4 weeks. 4 weeks ke baad. Huh? All right. All matters you will be getting your file the response affidavit. Give it to him. He will circulate.
1st of June.
Date, well,
16.
If you, Mr. Singhvi and Ms. Arora, if you want this to be responded also, you'll have to put it on affidavit.
I see. We will do that immediately today, Malus. Put an affidavit by tomorrow, within tomorrow.
Put it on an affidavit and then they shall respond to that also.
Served also on them
Your
tomorrow.
lordships, may I request a
Otherwise,
date
if you're happy with that petition, that content we
Malus,
will
your lordship
decide.
may add this, please, and Malus, it will be a composite reply. Let it
All
be.
right. File your affidavit and they'll give a reply.
Yes, yes.
All right.
Your lordships, may I
My lords,
request a
indicate
date
date,
in
Malus.
May if your lordships is convenient for your lordships.
They are putting a date in May.
Yeah, we are giving you a date.
1st of June, sir.
1st of June.
Perhaps some senior issue would. May I
Yes.
request a date in May, your lordships? Your lordships, may I request a date in May, your lordships, if possible?
End of
Just
May,
a
Malus.
minute. 4 weeks
1st of
expire
June
when?
onwards, maybe
Just
maybe a bit of.
They will
21st of May.
expire on 20th, Malus.
Can we have it on? No, we will be busy, no? Can we have it on then 27th of May?
Very well, very well.
Oh, 27th is a holiday. 28th of May.
Very well, very well.
All
Very
right. 28th of May.
well. Obliged, obliged.
We are grateful.
Wait for your lordships.
Item 12.
ये क्या है भाई बहुत भारी बात है.
Milord, before my landed senior starts, Milord,
Yes.
I'd like to point out to your lordship, Milord, we have filed an affidavit as soon as.
Yeah, back wages.
Milord, we went according to the order of this court to join. They have taken a stand that since the officers are not there, mill is closed, so we cannot allow him to join. So to that aspect.
Then we decide the issue.
Next, Milord, there are a series of writ appeals, Milord. The leading case is writ appeal 152.
No, but we can't. Those cases will abide, the judgment in those cases will abide by this.
Yes. Milord, that up to your lordship, Milord, since it has come to my knowledge, so I may.
Are you ready to argue or not today?
Today, Milord, since these things have come to my mind.
Tell us, Mr. Chamua, tell us frankly whether you are ready to respond to this. See, there are some passage for you not to, to challenge this back wages or something. Sort of, there's some passage to them. especially in cases where it has been declared a sick industry, and you had not made a single statement about your not having gained
Well,
employment.
that is, there are small, I can show to your lordship.
See,
there. Indirectly it was stated,
It
Milord.
must begin from you, and then, because they are claiming
Yes,
it,
yes.
they are supposed to lead evidence, but not without your initiating it.
I initiated.
Anyway, if you're ready, we will hear. We are ready to hear it.
Some other day, Milord, but because
Only, na, aap number, don't take another.
Milord, it's my duty to point it out, Milord, that
It's your duty to point out, but we will not be collating all such writ petitions. Once we decide the issue, we decide it.
My lord.
He is on a simple issue that this passage in the judgment, not Dipali, Dipali is in your favor. They read it from Maharashtra State Road Transport Corporation versus Mahadev Krishna Nayak.
My lord,
this judgment delivered in the month of February in the year 2025. It sums up all the law on the subject.
My lord,
and gives them that kind of leeway. Otherwise, your case is strong. Once it has been found that your dismissal was bad, then you have to be reinstated, and you have to be given.
Accepted that, my lord.
That they accept.
That part. We did not challenge that.
No, but back wages also. They say that.
Back wages.
You see, the judges have used very wonderful expressions. They say that this very spirit of the legislation cannot be whittled down by semantic jugglery. So what was the reason why this was not done? You perhaps, both of you, one had abused, the other had assaulted. That could be no ground, because if there is no evidence to that effect.
My lord,
Anyway, if
what
you're
is the
ready,
evidence?
we will argue.
Just, if I may read one line.
No facts. You see, Mr. Chamo, you'll have to state only 3 things to defeat his claim.
Right.
You just have to say, I mean, this is not helping you out. This is not against him. But this is the contour under which you can argue possibly your case. Number 1, that notwithstanding this company being a sick one, but back wages would be necessary because law says so. Number 2, the main evidence was lacking, that one of them assaulted, the other abused. If that is there, then it is the dismissal was bad. If dismissal is bad, then you are required to be paid your back wages. Except in cases where it would appear to be absolutely iniquitous. So you have to demonstrate that it is not iniquitous now. Number 3, you came after 7 years. So you will be required to explain that all this while you did not have any gainful employment.
I didn't
Otherwise,
come after 7 years. It was they.
Process. Even if you came after 7 years, assuming, they say that because of the infrastructural delays, because of the court delays, proverbial delays, this time lag should not be the deciding factor. In that case, did you ever make a plea that you were not employed?
My lord, if I may respond to your lordship.
No, you will respond on the second date. We will not have piecemeal response.
No, my lord.
Have you filed your response affidavit?
Yes. Affidavit, my lord, to that fact that we went there and we were not allowed to join.
That affidavit comes later. That affidavit will consider for back wages from the date of reinstatement.
For back wages, my lord, the learned single judge has held that since there is no averment made in the from the side of the workmen, that is why the full back wages has been reduced to 50%. Now, if it is again reduced or it has been wiped out finally, then my lord, I believe the people.
Mr. Chamo, perhaps you are missing out on what we are asking you to do. You kindly show us from your averments before the learned single judge or before the tribunal.
Yes, it is there, my lord.
That you did not take any employment in the meanwhile. Then only the burden, the onus would lie on them.
That I understood. That is what I tried to show to your lordship. There is the evidence on affidavit filed before the labor court. The workmen stated, my lord, we were illegally terminated and we are entitled to full back wages. On this point, there was no cross-examination.
Forget it. Where is your
That is
statement?
why, my lord.
Where is your statement?
That
that
statement
for
is
all
not
this-
there.
Then they have a right to challenge it. If we further reduce it or we remove that. You have to explain, no? The company is sick.
No, there is no averment like this, my lord.
That's what they say.
No,
there.
they say this, there doesn't-
Anyway, we will be, which all matters? Let us have all these matters.
My lord, writ appeal 152, 2024 is a series of writ appeals. It will be listed, my lord, 19/5, 2026.
It is in tribunal's order. लेने से तो हम पूरा series एक कितना केस भरा है। तो सुन लेंगे। हाँ, सुन के खत्म करते हैं। Which are those matters?
My lord, one number I can provide, my lord. Writ appeal 152/24.
No, you don't provide one number. Otherwise, next day you will provide another number.
No, my lord, it's a series of, I can tell the other number also.
Give all the numbers related
I'll
to
give
this.
to the court master.
Even issues where even in cases where there have been issues with respect to maintainability of a writ.
Yes, this writ appeals, this is the questions raised here. The writ appeals are, intra-court appeals are
Okay,
not.
let this appeal be listed along with, give the name.
Writ
by-
appeal number 152/24.
We are not concerned with that kind of a response. You find out, give us the names, numbers, and then
I'm giving to the court master right now.
give it to the court master in the evening or in the recess.
Right now, my lord, with my.
Right now, we will be doing other matters. Right now,
His next date is 19/5.
19/5.
Yes.
Let's go along with on 19/5.
Yes, Lord.
Michael can.
13. Assay.
Item?
13.
Looking at the order dated 6/3/2026 passed by DB1, I think he has applied his mind. Let it go before him. Yes, Mr. Das.
I have no objection.
That is the practice which I adopt. If
Absolutely.
it is only notice all that, but he has disclosed his mind. Detailed order could be a statement of fact, but he has disclosed his mind. So let it be decided by him. Let this matter be listed before DB1
Before DB1.
as that bench has already dealt with
Michael, sir.
the issue,
Sir.
this case on an earlier occasion. On any date that you want, we will make a request.
May, somewhere in the month of May.
I did this on so and so, preferably on so and so.
12 May. 12 May.
15th
15. 14.
15th of May. 14. 14. 15.
Oh, 15 May.
May.
Item 14.
Registry may be directed to reflect my name.
The name of the learned counsel for the parties ought to be reflected in the cause list henceforth. This will also go to this item. Who appears in this matter? Item number 14. This also goes there.
Only notice was issued, my lord, on the previous occasion.
Oh, I think this we will, this I think should be listed along with that where we have issued notice.
My lord, this is a separate matter.
This department dismissal.
This dismissal. Okay. Let it go before. Let this case be listed before DB1, who has dealt with this case on an earlier occasion. Let the matter be placed before DB1 on, give a date. On so and so preferably.
14 May.
So we'll get up for a while.
Yes, Lord. No.
Back in 5 minutes. Yes.
Item 15.
Such a few minutes ago, they have served us affidavit filed by them. Our situation is very pathetic because the last flood in last Sunday night, I have got the information from the petitioner today at 10 a.m. some residents are still not able to come out from their houses. Some students are not able to go schools. So they have filed their affidavit. We will respond to it. Lordship, there is my small prayer to appoint a nodal officer till final disposal of this petition, because the latest experience of the petitioner is that during the last flood,
You look into the affidavits and then we shall decide what is to be done.
there is a submission in my petition at para 25. Because the Lordship, in last experience, what happened, Lordship, there are few pumps
No,
installed.
we are keeping it next week. This is urgent. You just go through it.
Next week, they'll fix.
Next week, we are placing it.
Yeah.
In the meantime, we are not going to do anything unless we see. It has to be dealt with in a holistic manner
Yeah.
and we shall have it done. This can't go on. Look at the affidavit and then please enlighten us also. Like, the affidavit filed on behalf of the respondents has been served upon the learned counsel for the petitioner only today in court. Full stop. He would like to go through the same before addressing this court. For the aforesaid purpose, a short adjournment has been sought for. Full stop. Let this matter come up for consideration on just after a week. Next Tuesday.
Excuse me.
देखते हैं.
28 April. Wait. 28 April. For hearing, item 20 and 21.
18 नहीं है.
It's on.
18 भी adjournment. Yeah.
Only 2021 and 22.
I am for 21 and Lordship on last occasion given certain direction to the, my lord, the learned council.
May I please your Lordship, my lord, Lordship, in preference to your Lordship order, Lordship, Mr. Excadas said with the Registrar General, Lordship, and we have received some instruction, Lordship, and we like to bring on a record.
As
Bring an
prayed for
affidavit,
on behalf of the respondents, let this matter come up for consideration on our date after 4 weeks. We are dealing with it every day, Mr. Chamaria,
Lordship,
after 4 weeks.
25/5.
yeah, if don't mind, Lordship, can I, any date fix, man, any date?
26
No,
May.
you stay in this courtroom and you don't know that in every case, I mean, no case is left undated.
26 May.
Very good.
deeply obliged.
Item 22.
Wait, please, Lordship.
Yes.
Lordship, Mr. AC, sir, is appearing in this case, Lordship, and
Nine.
it's on Lex report number 8. So some difficulty today, Lordship.
What I propose is that my submissions, your Lordship may kindly. And he may,
No,
on
that-
last 2-3 occasions on.
Doesn't matter, doesn't matter. When was this law passed? This amendment, when was it carried on?
2018.
17.
17.
17.
Governor assented on 31/18. And there is a 2 division bench judgment I have already provided, which says whether the council doesn't have the power to pass any law relating to anti-defection. 2 judgments are there already,
Meghalaya, relating to Meghalaya.
Nagala and Mizoram. There is a Supreme Court judgment also, my lord, saying that, my lord, in particular subject, they cannot go beyond the subject assigned to them. And the matter is pending before the
The
parliament.
court dispute petition with respect to the validity of the 42nd Amendment Act and incorporation of Rule 18A in particular by the NC Hills Autonomous Council allowing disqualification of elected council members in case of defection from their political party. which the petitioners is beyond the constitutional mandate of the council. The 42nd Amendment Act and Rule 18A, capital A, the petitioners urge, a replica of the anti-defection law in the 10th schedule, which is applicable to members of parliament and the state assemblies. The council does not have any legal power, the 6th schedule, to make such a law. Hence the prayer for declaring it virus. The background facts are that the 6th schedule of the Constitution was created to give tribal areas in Assam and a few other states a special form of self-governance through autonomous district councils. The NC Hills Autonomous Council, NC Hills Autonomous Council was first created in the year 1952. Later, some extra lawmaking powers were given to the council through constitutional amendments, sometimes in 1995 and 2003. However, these powers allow the council to make laws only on a limited list of local subjects, namely primary and secondary education, health, agriculture, roads, markets, fisheries, minor irrigations, etc. Nowhere either in the 6th schedule nowhere in the 6th schedule, even nowhere in the 6th schedule of the Constitution of India, any provision giving the power to the council to legislate a law regarding disqualification of its own elected members on defecting from their political parties. This power has specifically been given to the parliament and the state legislature through the 10th schedule. Mr. Mohanta, learned senior advocate for the sorry. Mr. B.D. Das, learned senior advocate for the.
For your lordship has very nicely on the only. If your lordship allows me to add it.
Just a minute, we are adjourning the matter today. Mr. B.D. Das, learned senior advocate, has submitted that the other hill councils in the state of Assam, namely Karbi Anglong Autonomous Council and Bodoland Territorial Council, have not come up with any such anti-defection law. Notwithstanding the approval of His Excellency the Governor of Assam, the legislation, the impugned legislation, cannot be sustained. There is yet another aspect to the matter which has been highlighted by Mr. Das. 2019, the central government had introduced the Constitution 125th Amendment close bill in the Rajya Sabha to add this power in the sixth schedule. Which bill is still pending. The consideration of the houses, consideration of the house. For bringing in such a law, the Constitution, Mr. Das asserts, required to be amended.
We want to amend para 2 of the section. Para 2 of the para 2.
All right. An adjournment has been sought today on the ground of unavailability of the learned AG who is to address us, who is to address this court over the issue. Let this matter come up for consideration on after 2 weeks. What AG will be here? There are two views here.
Here, man.
Huh?
These here. They
Unavailability in this court. He is here, but mentioning has been made, perhaps there's something going on in court number 8 where all lawyers are busy. There are two views, Mr. Counsel. You also get ready. This is not a big thing. Re-notify or
12/5. 12/5.
12/5. और कुछ नहीं, hearing